morning, everyone. I'm Vermi Omblero. I'm a law student of Mindanao State University, Iligan Extension. And this is for my Criminal Law 1 class, which is under Attorney Suno. So, let's discuss today what is criminal law and the revised penal code of the Philippines. Articles 2 to 11. Of course, we will mention Article 1 as part of the articles stated in the revised penal code. So let's define first what is criminal law. Criminal law is a branch or division of substantive public law which defines crimes, treats of their nature, and provides punishment. So there are also limitations on the power of Congress to enact penal laws. It must be general in application. It must not partake of the nature of an ex post facto law, and must not partake of the nature of a bill of attainder, and must not impose cruel and unusual punishment or excessive fines. And there are three characteristics of criminal law. There are namely the territoriality, the generality, and the prospectivity. So what is generality? From the word itself, generality, general, it means that the law is binding to all persons who reside in the Philippines. And territorial, it means the law is binding to all crimes committed within the national territory of the Philippines. But there's an exemption. The exemptions of territorial applications is enumerated in Article 2. So we will discuss that further later on. So here in prospectivity, the law does not have any retroactive effect, but there's also an exemption when the new statute is favorable to the accused. So there is also what we call the mala inse and mala prohibita. This is very important for us to understand what is mala inse and mala prohibita. So in violation of the revised penal code are referred to as the mala inse, which literally means that the act is inherently evil or bad, per se, wrongful. On the other hand, violations of special laws are generally referred to as mala prohibita. Note, however, that not all violations of special laws are mala prohibita. While intentional felonies are always mala inse, it does not follow that prohibited acts done in violation of special laws are always mala prohibita, even if the crime is punished under a special law. If the act punished is one which is inherently wrong, the same is mala inse, and therefore in good faith and lack of criminal intent is a valid defense unless it is the product of criminal negligence or culpa. Likewise, when the special law requires that the punished act be committed knowingly and willfully, criminal intent is required to prove before criminal liability may arise. So there are also some maxims. We will mention some maxims in criminal law. So one of these is the nullium crimen nullium penens sine lege. There is no crime when there is no law punishing the same. This is true to civil law countries, but not to common law countries. Because of this maxim, there is no common law crimes in the Philippines. No matter how wrongful, evil or bad the act is, if there is no law defining the act, the same is not considered a crime. So that's the difference. When there is no law punishing it, that is not a crime. So next maxim is the actus non passet reum nisi min sit rea. The act cannot be criminal where the mind is not criminal. This is true to a felony characterized by dolo, but not a felony resulting from culpa. This maxim is not an absolute one because it is not applied to culpable felonies or those that result from negligence. So the sources of criminal law here is the revised penal code and special penal laws enacted with the Philippine legislature punishing offenses for omissions. So let's proceed now to the articles of the revised penal code of the Philippines. So let me mention the Article 1. Article 1 states that this code shall take effect on the first day of January 1932. Let's proceed to Article 2. In Article 2, except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, its interior waters and maritime zone, but also outside of its jurisdiction against those who, number 1, should commit an offense while on Philippine ship or airship. Second, should forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippine Islands, should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number, while being public officers or employees should commit an offense in the exercise of their functions or should commit any crime against the national security and the law of nation defined in Title 1 of Book 2 of this code. So, what is it all about? So, let's put it in a simple sense. So, let's try to understand what is it in Article 2. So, it is important to note that there are rules as to crimes committed aboard foreign merchant vessels. There are two rules, the French rule and the English rule. So what is the French rule? Such crimes are not triable in the courts of that country unless their commission affects the peace and security of the territory or the safety of the state is endangered. In English rule, which is applicable to the Philippines, such crimes are triable in that country unless they merely affect things within the vessel or they refer to the internal management thereof. And there are two situations when the foreign country may not apply its criminal law even if a crime was committed on board or vessel within its territorial waters, and these are when the crime is committed in a war vessel or a foreign country, because war vessels are part of the sovereignty of the country to whose naval force they belong. So second is when the foreign country in whose territorial waters the crime was committed adopts the French rule which apply only to merchant vessels except when the crime committed affects the national security or public order of such foreign country. So there are also requirements of an offense committed while on a Philippine ship or airship. So first is it must be registered with the Philippine Bureau of Customs. Second, ship must be in the high seas or the airship must be in international airspace. Under international law rule, a vessel which is not registered in accordance with the laws of the country, of any country, is considered a pirate vessel, and piracy is a crime against humanity in general, such that whenever the pirates may go, they can be prosecuted. So another example is U.S. versus Bull. So what is it about? So a crime which occurred on board of a foreign vessel which began when the ship was in a foreign territory and continued when it entered into Philippine waters. It is considered a continuing crime, hence with the jurisdiction of the local courts. So as a general rule, the revised penal code governs only when the crime committed pertains to the exercise of the public officials' functions, those having to do with the discharge of their duties in a foreign country. The function contemplated are those which are under the law to be performed by the public officer in the foreign service of the Philippine government in a foreign country. There is also an exemption. So the revised penal code governs if the crime was committed within the Philippine embassy or within the embassy grounds in a foreign country. This is because embassy grounds are considered an extension of sovereignty. So Paragraph 5 of Article 2 use the phrase as defined in Title 1 of Book 2 of the Code. This is a very important part of the exemption because Title 1 of Book 2 does not include rebellion. So, because the title of Book 2, which is entitled Crimes Against National Security. So, let's proceed now to Article 3. Acts and omissions punishable by law are felonies. Acts and overt or external act. Omission is failure to perform duty required by law. And felonies, acts and omission punishable by the revised penal code, and crime acts and omission punishable by any law. So, what requisites must concur before a felony may be committed? There must be an act or omission. Second, punishable by the revised penal code. And third, the act is performed of the omission incurred by means of dolo or culpa. How felonies are committed? By means of deceit or dolo. There is deceit when the act is performed with deliberate intent. The requisites here is the freedom, intelligence, and intent. Examples: murder, treason, and robbery. Criminal intent is not necessary in these cases. When the crime is the product of culpa or negligence, reckless imprudence, lack of foresight, or lack of skill. Second, when the crime is prohibited act under a special law or what is called mala prohibita. In criminal law, intent is characterized into two. We have the general criminal intent and specific criminal intent. General criminal intent is presumed from the mere doing of a wrong act. This does not require proof. The burden is upon the wrongdoer to prove that they acted without such criminal intent. In specific criminal intent is not presumed because it is an ingredient or element of a crime, like intent to kill in the crime of attempted or frustrated homicide, parricide, murder. The prosecution has the burden of proving the same. So, the distinction between the intent and discernment. Intent is the determination to do a certain thing, an aim or purpose of the mind. It is the design to resolve of determination by which a person acts. On the other hand, discernment is the mental capacity to tell right from wrong. It relates the moral significance that a person has to his act, and relates to the intelligence as an element of dolo, distinct from intent. So let's distinguish also intent from motive. When we say intent, it is demonstrated by the use of a particular means to bring about a desired result. It is not a state of mind for committing a crime. On the other hand, motive implies motion. It is the moving power which impels to do all a crime may be committed without motive. If the crime is intentional, it cannot be committed without intent. Intent is manifested by the instrument used by the offender. The specific criminal intent becomes material if the crime to be distinguished from from attempt or restricted stage. So, by means of fault or culpa, there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. And imprudence is deficiency of action, and negligence is deficiency of perception, failure to foresee impending danger usually involves lack of foresight. So, the requisites for that is freedom, intelligence, imprudence, negligence, lack of will or foresight, and lack of intent. The concept of criminal intelligence is the inexcusable lack of precaution on the part of the person performing or failing to perform an act. If the danger impending from the situation, it clearly manifests. You have a case of reckless imprudence. But if the danger that would result from such imprudence is not clear, not manifest, nor immediate, you have only a case of simple negligence. Mistake of fact. Mistake of fact is a misapprehension of fact on the part of the person who caused injury to another. He is not criminally liable. The requisite for this is that the act done would have been lawful, but the facts have been as the accused believe them to be. Intention of the accused is lawful. Mistake must be without fault of it must be out of full mistake must be without fault of carelessness. So example of this is the United States versus Achong. In United States versus Achong being afraid of bad elements, locked himself in his room by placing a chair against the door. And after having gone to bed, he was awakened by somebody who was trying to open the door. He asked the identity of the person, but he did not receive a response. Fearing that the intruder was a robber, he leaped out of bed and said that he will kill the intruder should he attempt to enter. At that moment, the chair struck him, believing that he was attacked. He seized a knife and fatally wounded the intruder. So this is a mistake of fact. Mistake of fact would be relevant only when the felony would have been intentional or true dulo, but not when the felony is a result of culpa. When the felony is a product of culpa, do not if a felony is a product of culpa. So let's proceed to Article 4 of the Revised Penal Code. So Article 4, criminal liability shall be incurred by any person committing a felony, although the wrongful act done be different from that which he intended. So causes which produce a different result. So mistake in identity of the victim, injuring a person who is mistaken for another. So error in personae is mitigated if the crime committed is different from that which was intended. If the crime committed the same as that which was intended, error in the presence does not affect the criminal liability of the offender. In mistake of identity, if the crime committed was the same as the crime intended but on a different victim, error in personae does not affect the criminal liability of the offender. But if penalty for the lesser crime will be applied. So that's how it is. So we have also mistake in blow, like hitting somebody other than the target due to lack of skill or foresight. So, and we have all injuries result is greater than that intended, causing injury graver than intended or or as expected. So the requisites for this is the felony was intentionally committed. The felony is the proximate cause of a wrong done. And what is the doctrine of proximate cause? The doctrine of proximate cause, such adequate and efficient cost, as in the natural order of events and under the particular circumstances surrounding the case, which would necessarily produce the event. So the requisites are the direct, natural, and logical cause produces the injury or damage, broken by any sufficient intervening case, without which is the result would not have occurred. The proximate cause is negated by active force or distinct act or fact absolutely foreign from the felonious act of the accused, which serves as a sufficient intervening case. Resulting injury damage is due to the intentional act of the victim. So the second one is by any person performing an act which would be an offense against persons or property were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Requisites for this are act would have been an offense against persons or property. Act is actual violation of another provision of the code. So that is under Article 4, criminal liability shall be incurred. So there are two ways. By any, again, I will repeat, by any person committing a felony, although the wrongful act done be different from that which he intended, and by any person performing an act who would be an offense against person or property were it not for the inherent impossibility of its accomplishment or an account of the employment of inadequate or ineffectual means. Now let's proceed with Article 5. What is Article 5? Whenever a court has knowledge of any act which it may deem proper to repress and which is not punishable by law, it shall render the proper decision and shall report to the Chief Executive through the Department of Justice the reason which induced the court to believe that said act should be made subject of legislation. In the same way, the court shall submit to the Chief Executive through the Department of Justice such statement as may be deemed proper without suspending the execution of the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense. When a person is charged in court and the court finds that there is no law applicable, for court will acquit the accused and the judge will give his opinion that the said act should be punished. In paragraph 2 does not apply to crimes punishable by special law, including illegal possession of firearms or drugs. There can be no executive clemency for these crimes. So in Article 6, consummated felonies as well as those which are frustrated and attempted are punishable. A felony is consummated when all the elements necessary for its execution and accomplishment are present, and it is frustrated when the offender performs all the acts of execution which would produce the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. There is an attempt when the offender commences the commission of a felony directly by overacts and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. So, there's also development of a crime. So the internal acts intent planned, usually not punishable. External acts prepared, preparatory acts, acts tending toward that crime, and acts of execution, acts directly connected to the crime. So what is this desistance? So desistance on the part of the offender negates criminal liability in the attempted stage. Desistance is true only in the attempted stage of the felony. If under the definition of felony, the act done is already in the frustrated stage, no amount of desistance will negate criminal liability. The spontaneous desistance of the offender negates only the attempted stage, but not necessarily all criminal liability, even though there was desistance on the part of the offender, and if the desistance was made when acts done by him already resulted to a felony, the offender will still be criminally liable for the felony brought upon his act. So, and that had performed all the acts of execution. So there's always, so we have to keep this in mind, that the distinction between consummated, frustrated, consummated, frustrated, and attempted. So from the statement alone in Article 6, we could distinguish what are the difference between the three. Okay, so let's proceed with the Article 7. Light felonies are punishable only when they have been consummated without exemption of those committed against persons or property. Examples of light felonies are slight physical injuries, theft, alteration of boundary marks, malicious mischief, and intriguing against honor. In commission of crimes against properties and persons, every stage of execution is punishable, but only the principal and accomplices are liable for light felonies, accessories not. In Article 8, conspiracy and proposal to commit felony are punishable only in the cases in which the law specially provides a penalty. Therefore, a conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. There is proposal when the person who has decided to commit a felony proposes its execution to some other person or person. Conspiracy is punishable in the following cases: treason, rebellion, or insurrection, sedition, and monopolies, and combination in restraint of trade. Conspiracy to commit a crime is not to be confused with conspiracy as a means of committing a crime. In both cases, there is an agreement, but mere conspiracy to commit a crime is just punished except in treason, rebellion, or sedition. Even then, if the treason actually committed, the conspiracy will be considered as a means of committing it, and the accused will all be charged for treason and not for conspiracy to commit treason. So now let's discuss about what is Article 9. Grave felonies are those to which the law attaches the capital punishment or penalties, which in any of their are reflected in accordance with Article 25 of this code. Less grave felonies are those which the law punishes with penalties which in the maximum period or correctional in accordance with the above mentioned article. Light felonies are those infractions of law for the commission of which the penalty of arresto mayor, or a fine not exceeding 200 pesos or both is provided. So capital punishment, usually it's about death penalty. And penalties, imprisonment, like grave, 6 years and 1 day to reclusion perpetua. Less grave, 1 month and 1 day to 6 years. Light, arresto menor, 1 day to 30 days. So let's proceed now to Article 10. So offenses which are in the future being punishable under special laws are not subject to the provision of this code. This code shall be supplementary to such laws unless the latter should specially provide the contrary. For special laws, penalties should be imprisonment and reclusion perpetua, etc. Offenses that are attempted or frustrated are not punishable unless otherwise stated. Plea of guilty is not mitigating for offenses punishable by special laws. No minimum, medium, and maximum periods for penalties. No penalty for an accessory or accomplice unless otherwise stated. So, the provision of our revised penal code applicable to special law. Article 16, participation of accomplice. Article 22, retroactivity of penal laws if favorable to the accused. And Article 45, confiscation of instruments used in the crime. So, let's go to Article 11. Article 11 just defines circumstances. Those wherein the acts of the actor are in accordance with law, hence he is justified. There is no criminal and civil liability because there is no crime. Self-defense. Reason for lawfulness in self-defense because it could be impossible for the state to protect all its citizens, and also a person cannot just give up his rights without any resistance being offered. Rights included in self-defense. Defense of persons and defense of rights protected by law. Defense of property. The owner or lawful possessor of a thing has a right to include any person from the enjoyment or disposal thereof. So, for this purpose, he may use such force as may be reasonable necessary to repel or prevention an actual or threaten unlawful physical invasion or usurpation of his property. Defense of chastity. Elements. Unlawful aggression is a physical manifesting danger to life or limb. It is either actual or imminent. And we have also some requisites for that, and there are 2 reasons necessary of the means employed to prevent or repel it. Requisites is means were used to prevent or repel, then means must be necessary, and there is no other way to prevent or repel it, and means must be reasonable depending the circumstances, be generally proportionate to the force of the aggressor. The rule here is to stand your ground when in the right which may be invoked when the defender is unlawful assaulted, the aggressor is armed with a weapon. And the rule is more liberal when the accused is peace officer or who, unlike a private person. So yes, that's very important to know. And we have also this lack of sufficient provocation on the part of the person defending himself. So we have to remember the requisites for that to be considered under the Article 11, justifying circumstances. And defense of also we have this one, defense of a relative. If we have self-defense, we can also have this defense of relative. So the elements here is unlawful aggressor, the reasonable necessity of the means employed to prevent or repel the attack, and in case of provocation was given by the person attacked, that the person making the defense, but making the defense had no part in such provocation. So I will just going to end our discussion for today. So we will have another discussion for tomorrow about the another articles. So thank you very much for your time for listening on this video, and I hope I made this meaningful for you guys. Thank you so much and good day.